Good evening and welcome to the 29th episode of the South African Equestrian Federation's podcast, From the Horse's Mouth. Tonight, we're talking about being social media savvy. Social media and technology, of course, offer us incredible convenience and connectivity, allowing us to stay connected or create connections with family and friends around the world. It's great for disseminating information and research to greater groups with massive ease, as well as creating civic engagement, besides the fact that it's ultimately being used as a fantastic marketing tool. But on the downside, these platforms make it incredibly easy for us to thoughtlessly engage in bullying behaviors, share false or harmful information, and especially in teens, but really something that affects everyone, is the constant blend of unrealistic comparisons, along with a very literal addiction that can be very detrimental to our mental health. And beyond that, in 2023, posting the wrong thing can very literally be career ending. So tonight, we're speaking to a fellow equestrian, Emma Sadler, Africa's leading expert on social media law. Her company, the Digital Law Company, was founded in 2013 and specializes in educating and advising corporates, employees, schools, and universities on the legal, disciplinary, and reputational risks of social media. Emma graduated her BA LLB cum laude from the University of Witwatersrand and also holds, Emma, this CV is ridiculous. I'm going to have to stop at some point. LLM in Information Technology, Media and Communications from the London School of Economics, and additionally is a two-time author, and I can thoroughly recommend reading both of those books. So Emma, thank you so much for joining us tonight.
It's an absolute pleasure. It's been tricky to organize both of our schedules, but I'm very pleased to be speaking to you. And
I blame the children.
Horsey community is my people, so I wasn't ever going to say no.
Thank you so much. So Emma, tell us a little bit about how you got into digital law. I mean, it's interesting that you've been doing it for 10 years. Well, it's something that's really only come to the mainstream focus, I'll say, in the last 5.
Yeah, so it's a funny one, George, because I speak at schools just about every day, right? And then often the kids afterwards come and say, "Oh, ma'am," which makes me feel old, but I am, I guess. "Ma'am, how did you know you wanted to be a social media lawyer?" And I have to giggle because there was no such thing as social media.
Yeah.
Even when I was at university, there was no such thing as social media. I remember my sort of first glimpse into the world. I think it was in my first year of working, and I remember BBM was like a revelation, and Facebook, my brother sat me down and he was like, "You got to make a Facebook account." And I was like, what is this? And so it all happened so damn quickly. And I was so lucky because I did my articles at one of the best law firms. I was at Weber Wenzel. Then I went and I stayed on there for a bit. And then I went and I studied in London for a bit. And I did a master's at the London School of Economics. And it was so luckily timed because it was just as everything was shifting from traditional media, which was the law that I had been specializing in, to digital media. So it was everything from like tweeting the courtrooms, the Julian Assange WikiLeaks thing, liability for user-generated content. I'm already starting to sound like a lawyer, but like who's responsible for stuff we're putting on social media? And then it was just a very academically indulgent year because I came back and I was a little bit ahead of the curve. I went back to Weber Wenzel for a bit, and then I decided that I would try and make a go on my own. And for me, I feel so passionately about the educational side of my business because I don't need to tell you, when people mess up on social media, it can have such serious and such long-term, sometimes irrevocable consequences. So for me, it's prevention is better than cure. And so I spend a lot of time giving talks to companies, schools, universities, conferences about everything to do with social media and the law. And every day is different. It's fabulous, but also can be quite upsetting and shocking.
Absolutely. What are some of the most common issues that you yourself deal with around social media, or that you see as being a space that we need to be aware of?
Yeah, so I think that the first big issue is this idea that freedom of speech is an absolute right. This idea, and it's something that we're seeing as America becomes more polarized. As the Trumpites become bigger Trumpites, that freedom of speech is the most important right. That freedom of speech is more important than any other right, and that's never been the case. So, of course, we all have the right to freedom of speech. It's a fundamental constitutional right. I would go so far as to say it's the cornerstone of our democracy. But it's not an absolute right. It's not a more important right than other people's rights. So my right to freedom of speech has to be balanced against your right to privacy and your right to dignity and your right to reputation, religion, equality. So it's this balancing act. Now, before the social media revolution, I used to spend days of my life going to speak to the journalists, especially the investigative journalists, especially the more controversial content. And I would spend so much time trying to teach people about what they were allowed to say and what they were not allowed to say. And if you did post something defamatory about somebody, in what circumstances was that defensible? And, you know, and these laws are pretty complicated. They're pretty nuanced. And suddenly we were all publishers. You know, if I think even,
that's a great way of looking at it.
You know, even when I was in matric, if I wanted to have my opinion published on a public platform, I could phone 702, and I wasn't brave enough for that. Things have changed. Or I could write a letter to the editor of the newspaper and hope like hell they published it. And that was kind of it. And now suddenly at the touch of a button,
everyone has the talking stick.
We have the ability to publish from one person to millions, and once it's out there, it's out there. The mantra that I'm teaching even at primary school level is digital content is dangerous content. You know, this idea that when something's digital, it's out of your control. It doesn't matter whether it's a WhatsApp message or a picture that you send as a disappearing view once message. As soon as that content exists, it is vulnerable to republication. And I think that that's what I'm seeing at the moment, to go back to your question, is that it's not so much people messing up directly on Facebook, Twitter, Instagram, although we do still see that. It's people messing up on more private platforms that get screenshot and captured and further distributed. And the other thing we see is people messing up in the real world, and that gets documented and put online. So somebody does something, you know, illegal, controversial, and it does come up in the horsey community. You know, you see somebody beating a horse to try and get it in the horse box, and you film it and you put it online, or all the content at the moment about Oliver Townend after badminton, and we see that kind of thing. So naming and shaming, when people are allowed to say it, people not thinking about the consequences of what they're saying.
Emma, that actually ties in with, I've got a few questions outstanding from people that they've sent to me already. And this is a reminder for anyone who's in the live chat that you can pop Emma a question. Someone said, what are the legalities around videoing other people without their permission, especially children?
So we have POPI, right? The Protection of Personal Information Act. And for people who are watching this down the line, we're now in May 2023. POPI has been around for 2 years, and last week we got our first ever enforcement notice from the information regulator. It has so far been a total storm in a teacup because, you know, we were all hysterical about POPI coming into force and we must spend fortunes becoming compliant and it's so terrifying and 10 million rand fines and jail time and everybody was hysterical about POPI. And I saw all sorts of fake news on social media about like you can't ever publish a picture of anybody without their consent because of POPI. That's nonsense, right? So when it comes to POPI, if you are processing somebody's personal information, then you do need to have consent or to fall within one of the other requirements for the processing of the personal information. Processing of personal information is just like, if I do anything with your personal information. So I've got your name, Georgie Roberts, I've got your phone number, I've got your ID number, I've got a picture of what your face looks like. When can I do anything with that content? Can I store it? Can I publish it? Can I use it in any way? So that is processing, right? So what a lot of people don't know is that there is what we call a household processing exemption, which basically means that if you're using somebody's personal information for domestic use, so I take a picture of my child because they came first in their lead rein class, and there's some other kids in the lineup, and I put it on my Facebook page and I say, I'm so proud of my little tot and she's so delicious and I want to eat her. I do want to eat her. Then I don't have to ask permission for the other parents because it's a household processing, it's domestic processing, right? If I took one of those kids after one of my talks at a school and I made them hold up one of my books and took a picture of them and put it on my digital law company Instagram account, that's a commercial processing. That I cannot do unless I've got consent of the parents. So I think there was a lot of hysteria about POPI. And I think a lot of it was kind of unfounded. Obviously, businesses need to be careful. If they're using personal information for commercial purposes, you've got to fall within the realm of POPI. And hopefully this first enforcement notice, which was issued last week, which was against the Department of Justice, and it was just it was outrageous, egregious. I mean, what happened was that there was a key person, an employee of the Department of Justice. So we're dealing with the courts, right? Who didn't renew their license to their malware. So then there was this ransom attack, and they got hold of thousands of court files, online court files, and the courts were brought to their knees for a few weeks, and they were demanding Bitcoin in order to get and they basically said, you've got to take disciplinary action against this person who didn't do their job. And that's the only one we've had so far. But that's not the only privacy concern we've got. We've also got the common law right to privacy, which is if you can show that you have a reasonable expectation of privacy in a particular set of circumstances, and somebody infringes it, then you can sue them. It really just means, is this private, right?
Okay.
In this circumstance, in this situation, is what I'm saying, is that what I'm doing private? So if I'm standing on stage speaking to 3,000 people at the Sandton Convention Center and somebody takes a photograph of me, are they infringing my privacy?
No realistic expectation of privacy.
No expectation, no legitimate or reasonable expectation of privacy. But if that same person comes to my house tonight and takes a picture of me naked in my bedroom, are they infringing my privacy? Absolutely, right? So it's the same person, same subject, same camera, different expectations of privacy. So there are a few things we need to talk about. The first is the more you look after your privacy, the more of it you have. So if you've never been on social media in your life, you have a higher legal right to privacy than the person who lives every 5 minutes of their lives online. That makes sense to us, right? If you've got an open Instagram account, you hashtag the hell out of everything, you don't have an expectation of privacy over that picture. If you've got a private account, you do. So the first test is, do you have a reasonable expectation of privacy in those particular set of circumstances? And there was just a brilliant case that came out of the Supreme Court of Appeal. And it was a case where a guy was cycling through a farm. There was a whole group of cyclists cycling through a farm in the Eastern Cape. And they took photographs of this horrific animal abuse that they came across. And they went back and they submitted it to this guy who's got this anti-animal abuse Facebook page. And he published it on the page, these pictures of the animal abuse, naming and shaming kind of a post, alongside the guy's name, his full name, the name of his farm, the address of his farm, his cell phone number, and a photograph of him holding his baby daughter. So the person who'd been named and shamed rushed off to court to get an interdict on the basis that this had infringed his privacy, and it was awarded. And the owner of the Facebook page appealed to the Supreme Court, and the Supreme Court said, okay, and this is a post-POPI world, which is very important. The Supreme Court said, okay, he published these 5 pieces of disparate information into this one Facebook post, but they were all publicly available. His name, his farm name, the address was on Google Maps, his cell phone number was on his website, and the photo of him holding his baby daughter was his profile picture on Facebook, which is set to private, no expectation of privacy. So it failed at the first hurdle. So the first step is to show you've got an expectation of privacy. Obviously, children, to answer your question, have a higher expectation of privacy. There are 2 defenses, though, if you do infringe somebody's privacy. The first is consent. So I say, Georgie, you can publish this naked picture of me. I give you permission. You can publish my cell phone number, how much money I have, my home address. I give you consent. The second offense is what we call public interest, but we should call public benefit. And it's where what you're exposing has benefit to the public. Really, it's where somebody's doing something illegal. Okay. So I'm thinking of some of these domestic violence cases that we've seen where footage has been released of actual domestic violence attacks. Now, somebody who's been named and shamed can't come forward and say, oh, what about my right to privacy? No, what privacy? When you do something illegal like beating up your wife, your privacy falls out the window, right? So don't think that you can rely on this privacy right to stop something illegal being exposed. So that's the first. So it's a long answer to your question, POPI. Don't worry too much about POPI if it's for personal use. And then, is there a reasonable expectation of privacy? Remember, the more you look after your privacy, the more of it you have. The more you look after your children's right to privacy, the more of it they have. If you can show you've got a reasonable expectation, you can have your privacy infringed in 2 instances: consent and public benefit.
Thanks. That's a really wonderful answer. Emma, when it comes to the legality of what we can and cannot post, especially in an equestrian space, and I think I'm thinking towards also naming and shaming, and I don't know if fake info falls under this or if that's a separate discussion. What can we realistically get into trouble for?
So defamation, to go back to your very first question, some of the biggest issues that I deal with. So privacy infringements, particularly image-based violence, I deal with a lot of that stuff. But defamation is the one that I deal with literally every single day. So defamation, when somebody hurts your reputation. So companies can sue for defamation. Individuals can sue for defamation. A dead person can't sue for defamation. Well, their estate can't, because the idea is that the personality rights, privacy, reputation, dignity, die with the person. But if you go online, George, and you say that Emma is just this terrible person, she's racist, she's a sexual predator, she abuses her horse, that is defamation. There are 3 requirements to defamation. The first is that it must be published. Now, here's something interesting. It doesn't matter whether it's been seen by one person or 1 million people.
Wow.
The requirement of publication is met as soon as one other person has seen the content. So it doesn't matter whether it's a WhatsApp group with 5 people on it, a WhatsApp status on Facebook, on Insta, on a private account, a public account. As long as one other person sees the content, it's been published. The second requirement is that it must refer to you either directly or indirectly. So if somebody writes an article about Emma Sadler or Emma Berkowitz, or which is my married name, or if somebody writes an article about that blonde social media lawyer, they're still talking about me, right? To your point about fake news, if somebody creates something, or somebody creates like an artificially generated, an AI generated image of me doing something dodgy, it's still defamation because it refers to me, even though it's not, it looks like it's me, right? So that requirement of reference is direct or indirect. And then the third thing is that it must hurt your reputation. Now, that doesn't mean you can't defame people. It does mean that if you're going to jump on the defamation bandwagon, you need a defense. And the 2 big defenses are, well, there's one defense, but it's got 2 components: truth plus public benefit.
Oh, that's interesting. Okay.
So that's very interesting, because in some countries you can say whatever you like as long as it's true. But in South Africa, we have this additional requirement of public benefit. So George, to your point, like, it takes away a lot of that just airing your dirty laundry on social media. I go on a rant about my loser ex-boyfriend and how he's frolicking around town with his floozy, and that poor girl doesn't know what's coming for her. The courts are saying, I'm sure it's true. I'm sure he is a loser. I'm sure he is frolicking around town with his new floozy. But it's not for the benefit of the public. The benefit of the public is not just what's interesting to the public. It's exposing somebody doing something illegal, hypocritical behavior. So I think there, when we're talking about our sport, like, I think that the more professional, the more senior is not the right word, but the real, like, people who are at the top of our sport, for me, have a greater duty because they're role models in our society. So I think we can hold them to a higher standard of conduct. And I think then their bad behavior is a slightly lower threshold for public benefit than a kid who's doing their first lead rein utility class. You know what I mean? So if you are going to defame a person or defame a company, then you've got to show that what you're saying is not just true, but also for the public benefit. But the truth is the big thing, right? Like, I can't go around saying Georgie beats up her horse unless I can prove. And this is where the onus lies. Onus is this legal word we use for duty. So the duty to prove is on the poster. So if I do a hashtag #MeToo status and I say, I went to a party and Mr. X touched me inappropriately, he's a sexual predator, then Mr. X sues me for defamation. It's not for him to show that he's not a sexual predator. It's for me to show that what I've said is true. And we are seeing so many defamation cases as a result of social media. And we're also seeing much bigger damages award, because I think that we're kind of getting the judicial recognition of how important reputation is in the digital age. You know, if I'm the victim of a campaign of defamation, harassment, bullying, and my name is completely ruined, that's going to directly impact the rest of my life, right?
I think it's really interesting. Perhaps the biggest thing to take away from that is that it doesn't matter whether it's on a WhatsApp group with one other person or whether you've now taken a screenshot and sent it on to multiple people. That's a really interesting thing. And maybe that's a good segue into what are some of the other social media laws that we need to be aware of in South Africa, Emma?
Yeah, so defamation and privacy are the big ones, but the third one that I use all the time in my business is the criminal offense of crimen injuria. Now, as I said, with defamation, it has to be published to somebody else. Crimen injuria, even if somebody sends you a direct message just to you and it hurts your dignity. So that's the definition of crimen injuria. If somebody seriously infringes your dignity, you can go and lay a criminal charge against that person. And if somebody says something directly to you that's so hurtful, so it can be racism, it can be homophobia, it can be accusing you of some terrible thing. We've just had a case with anti-Semitism in the Randburg Match Court. Even if it's a direct message, you can still go and lay this criminal charge of crimen injuria. So I like the crime of crimen injuria because it's very generic. We can use it in cyberbullying cases, racism cases, what other cases? Doxing cases, image-based violence cases. Somebody takes a photograph of my face and photoshops me onto a naked body and puts me on a porn site. That's crimen injuria. They're now specific crimes. So there's the image-based violence crimes under the Cyber Crimes Act and under the Films and Publications Act. I'm speaking in legal speak. Basically, if somebody shares a private sexual photo or video of you without your prior consent, 300,000 Rand fine, 4 years in prison. It's fabulous. It's brand new. It came into force last year. And we've been working on it for years. So it's completely thrilled about it. And it's a big sanction. And again, to your point about like, what if it's fake news? Again, there's a provision in that law which says that if the person depicted can be identified, is identified or can be identified. So even if somebody shares a picture of, I don't know, some private parts and says, this is Emma Sadler, even though my face isn't in it, I can still lay that criminal charge against them because of the indirect identification.
That's fantastic. Okay. And we see a lot of people hosting WhatsApp groups and Facebook groups all over the place. Besides the fact that individuals can be liable, are these administrators also, do they have a share in this blame or this liability?
100%. So what the law says in just about every country except America, but certainly so completely established in South Africa, is that if you have the ability to stop something from being published and you don't, you're legally responsible for it. So if somebody puts terrorism on my Facebook page, child pornography on my Facebook page, I have the ability to delete it. The law in South Africa says if I don't go and delete it immediately, I'm responsible for it. When I become aware of it. If I'm not aware of it, obviously I can't be held responsible for it. Then we've got case law to say, well, let me just take that a bit further. It means also if I Instagram something and somebody comments underneath my Insta post, something terrible, I can delete that. I can swipe and delete. And the law says if I don't go and swipe and delete, I become legally responsible for it. Because, so what Judge Satchwell said, who I think is also horsey, actually, she's fabulous. She said in the Dutch Reformed Church case, she said, if you have a Facebook page, it's like having a big green felt notice board, right? And then encouraging members of the public to come and stick their scrappy pieces of paper on that board. She said, because you have the ability to go and remove any of the scrappy pieces of paper, anything that stays there is your responsibility. That's in the same way that the editor of a newspaper is responsible for the content of its pages. So if we take that a bit further and we look at what WhatsApp's new settings mean. So basically, if you are the admin of a WhatsApp group now, as of sort of late last year, you have the ability to delete for everyone messages sent on that group. So if I'm on a group with like 10 other people and it's an eventing WhatsApp group, and somebody on that group says something completely unacceptable, even remotely unacceptable, then I, as the admin, can hold that message down and can say delete for me or delete for everyone. And if I press delete for everyone, it deletes from every single person on the group's chat. Now, because of this technological change, it means that if you're the admin of a WhatsApp group, you are now legally responsible for every single word that appears on that group.
So it's not something you should do lightly anymore.
No, 100%. But and I'm just thinking of there was, sorry, I could hear a toddler trying to break my door down. So let me phone and find out where the gatekeepers of the toddler are. But while I'm doing that, there's a toddler at my door. Can you come and get it, please? Thank you. Sorry about that.
We've had Rissa's dogs interrupting podcast. My child, it's part of the expectation now.
No problem. So sorry about that. So I'm thinking of this case that happened last weekend of November last year. So there was a WhatsApp group, and there was this dreadful. It was in the context of pit bulls, people calling for pit bulls to be banned, right? And there was this dreadful woman called Belinda Mago. You see what I did there? Defamation, but it's true and public interest, right? She is a dreadful woman. And she sent this voice note. It was a 1 minute and 8 second voice note on this WhatsApp group with like hundreds of people on it. And it said that, oh no, pit bulls shouldn't be banned, black people should be banned. And that's just the beginning. It gets worse from there, if you can even imagine it getting worse. It's unbelievably horrible. So she was arrested. She's been charged with crimen injuria. My guess is that she'll get 5 years in prison. You know, I think it is the worst piece of racism I've heard in the social media landscape of the last few years. But I don't want to talk about Belinda Mago. She's a baddie. She must go to prison. I want to talk about the admin of the WhatsApp group, because I believe he behaved in a way which means that he won't be held legally responsible for what happened.
That's interesting.
He recorded the voice note, so used somebody else's phone to record it. So he retained the evidence, held the message down, deleted for everyone, which means it deletes from the chat of all the hundreds of people on the group. So they have 512 people on a WhatsApp group now. And then he removed her from the group. Now, by doing those three things, I believe he will not be held legally responsible in any way.
It doesn't sound like there's much more he could have done. That's really
exactly. So it's a very good, I think it's a very good illustration to show you of how, I mean, yes, you do expose yourself to liability as an admin of a WhatsApp group, but there are ways to behave if there is illegal content sent, which absolves you. Of course, if you set up a group for the sole purpose of causing harm to another person, then I think that you're kind of on the hook. You set it up with that intention. But if you're just, and the defense that we use is the defense of innocent dissemination, which basically means, yeah, I'm responsible for it, but I can't be responsible for it because I didn't know. I couldn't have foreseen that on my street WhatsApp group, the baddie in number 22 was going to send this horrible meme. But as soon as he did, I behaved in a good way. So it is important because I think we're at the point where we're not just, we don't have to just be worried about what we're saying, but it's this responsibility that comes with hosting other people's views.
Absolutely. A question about intellectual property. How can we define it, and what are our rights to our own intellectual property on public platforms?
Okay, so disclaimer, I'm not an intellectual property lawyer. It's a very specialized field. But I can tell you from that there are two issues we're really dealing with people stealing our pictures from social media. The first is privacy. So can you show that you had an expectation of privacy? If you can, and somebody infringes it, you can sue them. But second to that is copyright. So copyright in South Africa subsists automatically. So in some countries, like in America, you have to go and register your copyright in content. In South Africa, provided something is like worthy of being protected by copyright. So it's not just like this is not worthy of copyright, right? Like this is my rambling and scrambling. But me taking a nice picture of you doing some lovely dressage, and I think it's excellent, and I'm going to sell it to you. That's absolutely the copyright subsists. In most pictures we post on Insta, for example, copyright subsists. Some of my more brilliant tweets, I would say copyright subsists in those tweets. So You can't use copyrighted material unless you're allowed to. There is a fair use defense in the Copyright Act, which is so old, and we're waiting for the new one to come into force. The Copyright Act we're dealing with at the moment is from 1978. Like, things have changed a little since then. But basically, you can use somebody's copyrighted works for educational reasons, for news. So if I write an article, for example, about the dressage championship that happened, and then I use your photograph to post it. In the article, I don't actually have to ask you, provided it's publicly available, because there's not a privacy issue. Provided I quote the author if it appears on the work, and say where I got it. So as long as just underneath it I say this is from Georgie Roberts' Facebook page, then I'm golden. I'm absolutely fine. So copyright is a tricky one. I mean, I see a lot of the photographers in the horsey world watermarking their content, and that's really to guard against people using your content without permission. It's there was even a way before we got specific legislation in America, so specific laws dealing with revenge pornography, image-based violence. People used to copyright those pictures. So say I'd sent you a nude and then you went and put it on one of these like revenge websites. I would go and take that picture and copyright it and then use intellectual property law to get the website to take it down, as ridiculous as it sounds. But when we're dealing with these companies in America, they take property rights much more seriously than personality rights.
Well.
Yeah, imagine my surprise. But to give you an idea of what this involves, I'm thinking of, I don't know if you remember that Sandy Hook shooting. It was one of those school shootings, like unthinkable. And there was a teacher who died protecting her class. And there were all these conspiracy theorists afterwards who were using her image, saying basically she was working in cahoots with the shooter and she was complicit in this attack. And it was absolute. And so they kept asking Facebook to delete these pages, and they didn't. And they kept asking, and they didn't. So they posthumously went and registered her profile, the picture they were using. They went and copyrighted it. I think actually they might even have trademarked it. And then they used the IP law against Facebook, and Facebook deleted it immediately, deleted all those pages immediately. So copyright is, and it's also a bit of a trick, George, if you ever have a page that you're trying to get deleted. If somebody started, the X company sucks page, to use the trademark infringement notice against Facebook because you own the trademark of X company, rather than defamation, Facebook's much more likely to, or Meta.
I suppose they see it as a much more black and white thing, perhaps.
And they also realize that, yes, because in America, defamation law is a little bit more robust. The protection of defamation, at least. But I think more so they see dollar signs, and IP infringements are more expensive. Yeah.
This is another incoming question, Emma. It literally just says, can we have clarity on what defines hate speech? I think it does come under your crimen injuria comments.
It doesn't. So hate speech is a different thing.
Okay.
So crimen injuria is a criminal offense. So basically there's two ways the law gets involved in our life. The first is criminal. The police come and arrest you. It's murder, rape, robbery, theft in the real world. But in the online world, it's hacking, it's password abuse, it's child pornography, it's grooming of children and showing pornography to children. It's crimen injuria, it's hate speech is in the process of being criminalized. Under the cybercrimes,
yet?
Not properly, and I'll tell you about it in just a sec. But no, not properly. So there's the hate speech and hate crimes bill, which is in the process, but it's not in force yet. That's not to say hate speech doesn't exist. It's just they're in the process of criminalizing it. Under the Cybercrimes Act, if you send somebody a threat of violence or a threat of damage to property, I'm going to beat you up tomorrow, I'm going to crash into your horse box and write it off, it's a criminal offense, even if I never see you again. So those are the criminal stuff. For those of you with children, the minimum age of criminal capacity in South Africa is 12. So under the age of 12, you can't be arrested. Over the age of 14, full criminal capacity. If your kid is 12 or 13, they look at the kid. How educated is the kid? How mature is this child? Should they know the difference between right and wrong? So that's criminal law. The other is civil law. I sue you, you sue me. So that's often defamation, infringements of privacy, getting a protection order against somebody under the Protection from Harassment Act, something very useful if you are being cyberbullied or stalked or threatened or harassed in any way. A protection order is a very efficient way of trying to combat it. But the hate speech law in South Africa changed fundamentally last year. And it was in the case of John Kolani, who is now dead, but he wrote an article on the front of the Sunday Sun newspaper, and it was called "Call Me Names, but Gay is Not Okay." And then went on this diatribe about how terrible being gay is and equated homosexuality to bestiality. And it was just this horrible, horrible article. So he was called to the Equality Court, the Human Rights Commission. They found him guilty of hate speech. And his lawyers appealed, but on the basis that the definition of hate speech was too narrow. So in the old days, hate speech was anything which was hurtful, harmful, or promotes or propagated hatred. And the courts, they never told us whether they were ors or ands at the end of those sentences, at the end of those things, right? So we didn't know if it had to be hurtful and harmful and a propagation or incitement of violence. Something being hurtful would be too broad a definition. Like if somebody says, "Emma, you're a fat cow," I'd be like, so, I don't care. But if somebody says something terrible, then hate speech is not just what's hurtful. So there was a narrowing of the definition from the Constitutional Court last year. And basically, there has to be some kind of promotion or propagation of hatred on one of the protected grounds. So absolutely, racism, xenophobia, homophobia, all of the protected grounds in the Constitution, any kind of promotion of hatred against people because of one of those grounds constitutes hate speech.
Emma, another question, a question about influencers. What defines a paid partnership, and is this a legal issue in South Africa?
Okay, so the law in South Africa is that the Advertising Regulatory Board has introduced a new appendix to its code of conduct, Appendix K. And Appendix K says that if you are an influencer, so if you are given goods, services, products, experiences for free, or you're paid to publish content, you have to disclose that is an influencer arrangement. And the recognized identifiers are #ad, #advertisement, #sponsored, or paid partnership. I was listening to a whole podcast last week. This is what kind of nerd I am, on whether #gift is a thing. It's not a thing, right? So it's got to be #ad, #sponsored, or paid partnership, right? And even if somebody gives you something for free, you need to disclose it. So there was a case with a woman called Candy Kane. She's an influencer in Cape Town, and she was given a Volvo car to drive. And she made these YouTube videos about how awesome the car was. And she didn't disclose that she'd been given the car for free. So she wasn't being paid money to produce that content, but she had been given the experience, really, the car for free. And the ARB sanctioned Volvo. They generally put the duty on the advertiser rather than on the influencer to comply. And the ARB can find against non-members. So people, it's like a voluntary system, the Advertising Regulatory Board. But there's just been a Supreme Court of Appeal judgment which says that they can find against even non-members. So they can't really enforce much, but they can say, when you got that saddle for free and you didn't disclose that you got it for free when you told everyone how amazing it was, you were in contravention of the code. So they can still hear these matters, even if you're not a voluntary member, and they can make findings against you. So I'm rambling, but there are really two requirements for influencers and influencer law. The first is you've got to disclose. It can't come across as organic. So if you're getting something for free or you're being paid for it, you have to disclose, because it can't be that you've got to disclose that there's this partnership. But the second thing, and this is very important, is that you have to have a contract
That's interesting.
With the influencer. Yeah. So absolutely not negotiable, even if it's like free stuff, even if it's, as I say, an experience. I've got this bush lodge and you've got a big following and I'd like you to come for the weekend and just post about, and you can come for free as long as you post. You have to have a contract and you have to disclose. And in the contract, you've got to have the compensation paid. So we're obviously dealing more with the paid influencer market. But if you look at the code, doesn't really distinguish. It basically says you've got to disclose and there's got to be a contract.
Good. Emma, what is the fine line between healthy criticism and cyberbullying?
Harm. If you're causing somebody harm, emotional, psychological harm, then I think we're starting to get into cyberbullying territory. It's a difficult one. There's not a proper definition. So under the Protection from Harassment Act, if you can show that you are suffering harm or a fear of harm, and it can be mental, emotional, psychological harm, financial harm, or a fear of financial harm, so people calling for a boycott of you, for example, or physical harm, somebody's threatened you with violence or you're worried for your own safety. And I'd say that's probably the closest I can get to in my cyberbullying work. And a lot of people think they can just say, criticism, let me get there in a second. So a lot of kids, when they're saying something ugly and it's actually bullying, they'll say, oh, no, I was just joking. That's absolutely not a magic wand.
A lot of kids. When
it comes to criticism, the law is pretty clear on the tallest trees must endure the most wind. So you can certainly, in my view, you have a bit more leeway to criticize somebody who's at the top of the sport than at the bottom of the sport.
Punch up, not down.
Sorry?
Punch up, not down.
Yeah, I think that's it's pretty accurate. And the other very accurate one is Michelle Obama: when they go low, we go high. But there is a fine line between criticism and cyberbullying. There's also a fine line between criticism and defamation. Invariably, criticism would constitute defamation. But if what you're saying is fair, it's an honest opinion. So yes, okay, here, I've got a better definition for you. If you're motivated by malice, it's cyberbullying.
That's nice. I like that.
If you're motivated by
public interest,
public benefit, so there's a special defense in South African law. I told you about truth and public interest, but if you're publishing an opinion, the definition, the defense is called fair comment. It should be called the honest opinion defense. And you've got to show four things. Should have had my nails done for this. I'm doing a lot of my fingers. The first is that it's your honest opinion. The second you're motivated by malice, you lose the defense of fair comment. The second is that you must, it must be based on truth or substantial truth. So I can say Jacob Zuma is corrupt because he stole 200 million rand, but actually it was only 150 million rand. Doesn't matter. The law doesn't mind about those inaccuracies, provided it's substantially, the nub of it is substantively true. The third thing is that it must be on a matter of public interest. And I can't remember what the fourth is. It's the wine, but you know what I mean? Like the one is different. The one is honest opinion and the other is malicious commentary. And I think that is, I think that's probably a pretty good answer.
Emma, what can we do if we feel that someone, what are signs that somebody who we love is at risk of being cyberbullied, and what can we do about it?
So I would say if you're being cyberbullied, you do three things: block, screenshots, tell. Block, screenshots, tell. So certainly if it's direct cyberbullying, you block the person. Don't press report. Often if you press report, it deletes all the content. We need the content. We need the evidence. Take screenshots, multiple screenshots. Even better, you use somebody else's phone to scroll through the content. And then if you're a child, you've got to tell an adult, any adult that you trust, whether that's a counselor at school, your parents, your friends' parents, somebody, an older sibling, a godparent, like somebody you trust, right? The things to watch out for is if you see somebody you've seen a change in behavior, a change in sleep with the kids, a big change in school marks, those are kind of red flags that this child might be cyberbullied or might be vulnerable to some kind of online harm. I'm a big fan of a parental control technology called Bark. You do have to pay for it, which sucks. But if you've got somebody who you think is high risk, who you're close to, I'm a very big fan of Bark because it monitors the messages and then gives you like a warning report about there's been suicidal ideation or racist content or bullying content or eating disorder content or whatever it is. And that's, I think, very useful. But for everybody else, if you don't think you've got a particularly high-risk child or you don't have a very young child, the parental control technology that comes standard is pretty adequate, I think. Screen time on the iPhones and Apple, what's it called? Google Family Link on the Android devices. Yeah.
A couple of tips, like 3 or 4 tips for posting on social media before you go, Emma, to wrangle your toddler.
Thank you. I don't think I even need 3 or 4. Okay, I'll take a few. The first is the billboard test. I've been shouting it from the rooftops since I started doing what I do. If you wouldn't put it on a huge billboard next to a photo of your face, your name, the name of your company, the names of your sponsors, and whatever it is you're about to say in digital format, whether it's a photograph you're going to send, a voice note, something you're going to put on Facebook, a photograph somebody's going to take of you at a party, or a video of you dancing on the tables at the Derby after party. If you wouldn't put it on the billboard, then don't let it exist in digital format. The second is that digital content is dangerous content. When something's digital, it's out of your control. And the third is my most scientific test. It's the jump in the tummy test. It's when you're just about to press send, post, tweet, share.
I love that.
And you get that feeling in your tummy that like, you know that one? It's just like you write, maybe having a fight with somebody and you write this, write this huge ranty message, and you're just about to press send and you get that, you know that one? Then close your eyes and think, dear Emma, would I put this on a billboard next to my name, my face, the name of my company, next to the busiest highway in Joburg? And if I wouldn't, then I'm going to say it to their face and make sure they're not recording. Because when something is out there, it's out there. And, the one shortcoming of the billboard test is that it doesn't sufficiently reflect how permanent the internet is. It's been around long enough now that we are even seeing sportsmen at the top of their game. I'm thinking of a guy who started playing cricket for England. It was the middle of last year. And he was in his very first test for England. Halfway through the test, they found tweets that he'd posted over 10 years ago when he was a teenager. It was Ollie Robinson. I don't know if that name means anything to you. Yeah. And they were totally unacceptable. And he was suspended from all forms of the game immediately. He was fined a huge amount of money. And it was from stuff from so long ago. So as I say, the only shortcoming of the billboard test is what I call the tattoo effect of the internet. And that is that the internet doesn't forget.
Tattoo effect of the internet. I love that. Emma, thank you so much for joining us tonight. It's always invaluable to have you, and you're such a great guest. We really appreciate it.
It's an absolute pleasure, and I hope you feel better soon.
Thank you. Thank you. If anybody needs to get hold of you, Emma, for any kind of questions, can they contact you at the Digital Law Company?
The Digital Law Company on Facebook and Instagram. On Twitter, I'm still at Emma Sadler. And my website, if you just Google the Digital Law Company, it'll come up.
Thank you, Emma. Thanks so much.
All the best.
If you've just joined us, we have just wrapped up being social media savvy in an equestrian world. Next week, we will be speaking to some of the leading medical experts in the country when it comes to African horse sickness, trying to separate fact from fiction. When it comes to both prevention and cure, what are we doing to genuinely help or perhaps hinder our equestrians? Thank you for joining us tonight. My name is Georgie Roberts, and we'll see you next week, Wednesday at 7 o'clock.